You're listening to Defending the Algorithm, an ongoing podcast series by the law firm of Houston Harbaugh PC in Pittsburgh, Pennsylvania, where we explore how artificial intelligence is reshaping the law and legal accountability. I'm Chris Jacobs, a partner here at Houston Harbaugh. I specialize in insurance litigation, commercial litigation, and IP litigation. And today we're looking at a case that could define how courts treat potential liability arising out of AI language models. Raine v. OpenAI. The lawsuit was filed in California State Court after the tragic death of a teenager whose parents allege that ChatGPT played a direct role in his suicide. OpenAI hasn't yet responded to the complaint, but many expect it will invoke Section 230 of the Communications Decency Act, the federal statute that protects online platforms from being treated as publishers of what users post. If that defense is raised, it will test whether Section 230's shield, built for the early web, can stretch to protect creators of generative AI. Chapter 1. When the algorithm becomes the speaker. In August 2025, two California parents filed suit against OpenAI Inc. in California State Court. They filed an amended complaint in late October 2025. They claimed that over the course of a year, their son used ChatGPT thousands of times, starting with homework questions, but moving into deeply personal conversations. According to the amended complaint, as his mental state declined, the chatbot allegedly, quote, became his closest confidant, end quote, even offering methods of self-harm instead of steering him to help. The parents' lawsuit asserts product's design defect, negligent failure to warn, and wrongful death, claims that place the system itself, not any user, at the center of causation. While Section 230 hasn't yet been raised as a defense, most expect it soon will be. And when language originates from a machine rather than a person, can its developer still claim to be a neutral publisher? That's the central question in Raine v. OpenAI. Chapter 2. The Predictable Defense. Section 230's Roots. Whenever defendants face tort claims tied to online content, the first instinct is Section 230. Passed in 1996 as part of the Telecommunications Act, it was Congress's way to encourage online speech while shielding platforms from publisher liability. The key line reads, "No provider or user of an interactive computer service shall be treated as the publisher or speaker of information provided by another information content provider." From those 26 words, courts built a sweeping immunity. In a 1997 Fourth Circuit case, Raine v. America Online, the court held that AOL could not be treated as the publisher of defamatory posts written by an anonymous user. Congress wanted to protect moderation, not punish it. Years later, in a 2023 Supreme Court decision, Gonzalez v. Google LLC, the court declined to narrow Section 230, holding that YouTube's recommendation algorithm still transmitted third-party content rather than creating it. Together, those two decisions created two guiding principles. One, a service is immune if it merely hosts or transmits another's information. And two, that immunity disappears if the defendant creates or develops the content. And that dividing line, facilitation versus creation, is precisely where Raine now stands. Chapter 3. The Tension. When the machine authored the words. The plaintiffs in Raine say that ChatGPT didn't repeat someone else's words. It generated new language that worsens their son's despair. That challenges Section 230's core premise, that an interactive service only transmits human speech. Under this view, generative AI doesn't simply host content. Each response is a fresh sequence of words derived from statistical patterns in training data, but never before written. OpenAI, however, will argue that ChatGPT just reformulates information supplied by others, that is, the human-authored training data, so it remains a neutral conduit. The plaintiffs will say the opposite, that ChatGPT creates original sentences and therefore acts as the author. If a court agrees with that position, OpenAI ceases to be a publisher and becomes a content provider, placing it outside of Section 230's protection. The Raine complaint even describes ChatGPT as empathetic, a closest confidant. If a system can influence emotion and behavior, judges may see it as an expressive entity rather than a service. That's where statistical prediction starts to look a lot like authorship. Chapter 4. The litigation stakes. The first test of algorithmic authorship. If OpenAI raises 230 as a defense, Raine would be the first case to test whether that immunity survives when the intermediary itself becomes the so-called speaker. OpenAI's likely argument? ChatGPT reformulates information written by humans and therefore acts as an intermediary. The plaintiff's counter. ChatGPT generates original compositions through its own modeling, making OpenAI the developer of the content. In California state practice, defendants can raise Section 230 immunity as a defense by demurrer and seek dismissal based on the allegations on the face of the complaint, similar to a Rule 12b6 motion in federal court. But given the factual complexity contained in the Raine complaint's allegations relating to AI training and system design, such a motion would face significant headwinds. Discovery will almost certainly be necessary to understand how the model was trained and what safeguards were in place, an unprecedented process in AI tort litigation. If Section 230 is extended, machine speech becomes derivative human expression. If not, generative systems become content providers with direct liability. Either outcome will draw the first real boundary of accountability for autonomous language generation. Chapter 5. Beyond publication. Toward product and design accountability. Even if Section 230 shields AI developers from speech-based claims, that doesn't end the story. Plaintiffs like those in Raine frame ChatGPT as a product, not a platform. Courts have already recognized that software can constitute a product when sold commercially and performing tangible functions. The Raine complaint takes this approach, alleging that OpenAI's design choices, including the absence of guardrails to detect suicidal ideation, made the system unreasonably dangerous. The focus isn't on what the chatbot said, but on how it was built. Was it foreseeable that users might rely on it for emotional support? Should it have included safeguards or warnings? By framing the claim as a design defect or failure to warn, plaintiffs sidestep Section 230 entirely. The case shifts from publishing to engineering. And that mirrors how tort law adapted to autonomous vehicles and software defects, for example. The duty isn't to make a system say something different, it's to know when not to speak at all. Chapter 6. Traditional defenses beyond Section 230. Even without Section 230, defendants retain traditional defenses: causation, foreseeability, misuse, assumption of risk, and comparative fault. First, causation. OpenAI will likely argue that the boy's tragic act was an intervening cause, breaking the chain of causation, an argument familiar from pharmaceutical and firearms litigation. But AI interactions are immediate. Prompt and response occur in real time, which may make proximate cause easier to prove than defendants expect. Second, foreseeability. If developers could not reasonably anticipate users would seek therapeutic advice, liability may not attach. Third, misuse and assumption of risk. A user who treats a chatbot as a therapist may be using it in an unforeseeable way. Fourth, comparative fault. Even if the system were defective, courts could apportion blame if warnings were ignored. And finally, duty to warn. Existing disclaimers like "don't treat this as a professional advice" may satisfy that duty unless marketing encouraged deeper reliance. Together, these doctrines show that tort law already has the tools to balance innovation and accountability. Chapter 7. Conclusion. Defending the algorithm. The law's encounter with generative AI is still in its early days, but Raine v. OpenAI shows that our existing doctrines can adapt. Section 230, the 26 words that built the web, was written for an era of human speech. Generative AI flips that premise. It arguably creates expression itself. Whether courts extend Section 230 immunity to that reality will mark the first boundary between algorithmic authorship and accountability. Even if immunity falters, the law remains equipped. Design defect, failure to warn, and negligence theories supply the framework. Causation, foreseeability, and comparative fault still govern how we assign responsibility. Innovation doesn't demand new laws so much as faithful application of old principles. Anticipate harm, act with reasonable care, and hold accountable those best positioned to prevent it. Technology changes. Duty does not. And as Raine v. OpenAI moves forward, it will help define that duty and the next chapter in our effort to defend the algorithm. I'm Chris Jacobs from the law firm of Houston Harbaugh PC in Pittsburgh, Pennsylvania. If you'd like to read our full article on Raine v. OpenAI and Section 230 immunity, you can find it at Houston Harbaugh's website at www.hh-law.com under the blogs link. If you'd like to discuss these topics further or explore any other similar area, please feel free to give me a call at 412-288-4019 or email me at jacobscm as in Michael at hh-law.com. You've been listening to Defending the Algorithm, where we explore the laws that shape artificial intelligence. Thank you for listening.